Hello and welcome. This is Code Files on your number one channel, Third Eye Africa TV. And Third Eye Africa TV is your number one channel when it comes to crime watch, crime prevention, investigative reporting, and of course, community safety. Corruption is one of the biggest problem we have in Nigeria today, cutting across all spheres of government, both at all levels and all arms of government. Corruption is said to be one of the major challenging problems bedeviling the country today. And you recall some episodes back, we dealt with a case that had to do with the former NSA to the former President Goodluck Ebele Jonathan, talking about Sambo Dasuki, who recently appeared in the FCT High Court to continue the trial of alleged criminal breach of trusts and money meant for arms that were traced to private accounts. And during the last hearing, which was on the 13th and 14th of January this year, the prosecution witness came up with more exhibits that contained bank statements, transactions, monies that were transferred from the NSA's account to two major private companies traced to the second defendants, talking about Aminu Babakusa. These private companies were Acacia Holdings Limited and Reliance Referral Hospital. The continued hearing on the 13th of January, the prosecution witness continued with this exhibit and continued to present bank details, bank statements, and transactions of how millions were transferred from the NSA's account to various accounts. The case was later adjourned that day to the following day, which was the 14th of January, when the presentation of exhibits continued. And at the end of the presentation, the trial judge, Justice Charles Agbaza of the FCT High Court, admitted some of those exhibits, and except when it came to the one that had to do with the statements that was obtained by the EFCC from the second defendant, which was objected by the counsel to the second defendant, claiming that it was obtained under torture and oppression. And that case was adjourned for trial within trial, which is going to be coming up on the 24th and 25th of February 2026. And however, this also is part of the questions that we try to address on this program when it comes to delay in justice dispensation. Several factors have been raised in terms of factors responsible for delay in prosecution and all of that. And you would agree with me that also public perception about the judiciary has also raised a lot of dust since this year. Recall the NBA Anti-Corruption Committee raised concerns about numerous unresolved cases and delay in justice dispensation, how it is eroding public trust in the judiciary. Recently also, a former vice presidential candidate talking about Pastor Tunde Bakare during the Ganifa Ohimi annual lecture, also raised concern about restoring integrity in our judiciary. And of course, the Court of Appeal marking their 50th anniversary also, highlighted, speeding up about 360 cases for pending for hearing at the appeal court as part of, part of this, activity, lined out to mark their 50th anniversary. The program is Code Files, and I'm not going to be in the studio alone, but I'm going to take a quick break here. When I come back, I will introduce my guest proper, who will join me to do some analysis around corruption pending cases in our court, and of course, corruption generally in the country, and of course in the judicial sector as well. Don't go away, I'll be right back in a moment. My name is Charles Agedu. Corruption remains one of the pressing challenges facing Nigeria today, cutting across all levels and arms of government. It also extends to the wider society, affecting both the public and private sectors, including ordinary Nigerians such as artisans. Many corruption cases have lingered in our courts for many years. The correctional centers are overcrowded with high number of inmates awaiting trial. The judiciary, they say, is the hope of the common man. But how hopeful should Nigerians be in the judiciary of today, where very senior legal practitioners are allegedly getting involved in corruption? In a New Year message, the Nigerian Bar Association Anti-Corruption Panel warned that unresolved cases are eroding trust in the justice system. The Anti-Corruption Committee of the NBA expressed worry over the silence and delays around high-profile corruption allegations involving lawyers. The Nigerian Bar Association Anti-Corruption Committee warned that unresolved corruption allegations involving lawyers are undermining public confidence in Nigeria's justice system and weakening the rule of law. The committee said that while the NBA recorded progress in institutionalizing anti-corruption measures in 2025, prolonged silence and delays around high-profile corruption allegations posed serious risk to accountability and transparency. The committee's chairman, Babafemi Badejo, said a major milestone in 2025 was the approval of the NBA National Executive Committee for the establishment of anti-corruption committees at branch levels nationwide. He said the decentralized structure was intended to strengthen grassroots engagement, localize ethic oversights, and embed anti-corruption vigilance across the legal profession. Mr. Badejo also noted that the observance of World Anti-Corruption Day by several NBA branches in 2025 reflected growing professional commitment to public education and ethical conduct. However, Mr. Badejo said the committee's reflections were tempered by deep concern over development capable of weakening public trust in legal and anti-corruption institutions. According to Mr. Badejo, prolonged and widely publicized corruption allegations involving lawyers have evolved beyond private legal dispute to become a broader test in Nigeria's commitment to accountability and the rule of law. He cited the 2025 case of Tali Shani versus Mike Ozekome, which was adjudicated outside Nigeria and involved allegations of forged document and identity manipulation, raising concerns about implications for Nigeria's identity management and accountability systems. Mr. Badejo said while the Attorney General of the Federation's public announcement of an investigation into the matter was appropriate, but that the absence of follow-up communication, interim findings, or clear timeline for conclusion was damaging to public confidence. He added that such opacity undermined Nigeria's obligation under the United Nations Convention Against Corruption, particularly provision of transparency in public administration, civil service participation, and protection of whistleblowers. The committee disclosed that it formally offered technical assistance to support a credible investigation into the allegations, but received no response from relevant authorities, describing the lack of engagement as a missed opportunity to reinforce institutional integrity. The NBA Anti-Corruption Committee also aligned itself with recent remarks by the Chief Justice of Nigeria, Kudirat Kekere-Ekun, on the central role of the rule of law in combating corruption, warning that rule of law could not be sustained amid systemic corruption. For 2026, the committee said its priorities would include advocacy for transparent, time-bound investigations into corruption allegations involving legal practitioners, expanded ethics training for lawyers, stronger whistleblower protections, strategic litigation, and sustained policy engagement. It also urged members of the legal profession to assess aspirants for MBA leadership position based on integrity, policy clarity, and demonstrable commitment to combating corruption. Mr. Badejo said the committee remained committed to promoting accountability, transparency, and ethical conduct within the legal profession as part of efforts to strengthen Nigeria's justice system.
There has been very little or no political will to drive this fight against corruption. People who say they fight corruption pay lip service to it. There is lack of political will on the part of Nigerian leaders to address the issue of corruption. Anti-corruption agencies are used as political baits against political opponents. The people, as of today, have some sort of negative perception about the judiciary. There are situations where lawyers have been involved even in money laundering. Go to court right now means it's an implied way of saying nothing will happen. The cost of justice as of today, can the ordinary man actually afford it?
Welcome back from that break. This is Code Files on Third Eye Africa TV. With me on the show is Ugochukwu P. Isiguzo. You are welcome to the program.
Thank you very much.
It's always a pleasure to bring you as a guest on this program.
Thank you for always having me.
Yes, I'm
happy to be here again.
Yes, I had you in my maiden edition when we had a conversation around issues surrounding the trial of the former NSA Sambo Dasuki. Recently, the trial continued. If you heard it in my intro, talking about what happened during the last 2 days session we had at the FCT High Court. I would like to just begin by just asking you a very straightforward question. What is your assessment of the fight against corruption in Nigeria today?
My assessment of the fight against corruption, you see, the truth of the matter is that when we were in law school, we had a lecturer who interestingly is now a judge. He would tell us, you are like the bird, Chichi Dodo. Okay. He does not like the excreta, but he likes the worm from the excreta. Okay. That is an expression of what is happening in Nigeria when it comes to corruption. People who say they fight corruption pay lip service to it. And when it comes to benefiting from that institution of corruption, you see them there headlong. The truth of the whole matter is that most people who are talking about corruption, President Muhammadu Buhari's government came to limelight on the trajectory of the fight against corruption. But you will agree with me that the corruption that was oozing out of his government was too much. In fact, we thought it had ended with the Goodluck Jonathan administration, only for us to come and see the Buhari administration. The Buhari administration trajectory for corruption only lasted for just about 6 months before Nigerians started seeing the reality that this was business as usual. The point remains that there has been very little or no political will to drive this fight against corruption. I keep on saying it. If you cut off the head, there is nothing you are using the body to do. The leaders of this country, from the president, there is a need to show seriousness with addressing these issues of corruption. When President Buhari came in, one of the little things I got to know that he was going to pay lip service to the issue of corruption was when it came to the issue of publicly publishing asset declaration. Let us see your asset declaration form like President Yar'Adua did. Publish it. Let everybody see it. It was a tug of war. So when the president is speaking and saying we're going to deal with and address the issue of corruption, and he is acting it out himself, why won't his vice president act it out? Why won't the civil service act it out? If the president has shown by his body language and all that, that he is not going to entertain corruption in his government. When I'm speaking, I'm not talking about President Tinubu specifically. I'm talking about as a matter of principles.
Okay.
The man who is sitting at the table at Ministry of Works and Housing will know very, very well that his minister cannot collect bribe. And so he will be afraid that you will report him to his minister. Why do we have a lot of our security agencies brazenly in the act of bribery and corruption? It is not far-fetched. There are even feelers that say that they give returns to their bosses. If you have an IG who comes and say, I don't want this thing anymore, it should stop. It will stop. So the fight against corruption in Nigeria, for me, is merely a lip service fight. And most people who are doing it, they do it to just, gain political cheap points. You remember a statement credited to Senator Adams Oshomole, former governor of Edo State, that when you join APC, all your sins
Are forgiven.
Somebody goes to steal the common patrimony of a nation or a state or a local government, and for the reason that he joins your political party,
His sins are forgiven.
his sins are forgiven. You clear him. How will that take us forward? Does that show you any seriousness to fight corruption?
So could that be responsible where we have these governors, politicians moving in droves to the All Progressive ruling party?
I may not know exactly what their intentions are for moving into the APC. But one thing I'm very, very sure is that it has to do with their political interests. They are considering their political interest. And that is one thing. Forget all these gist and all this talk that they say they want to protect the interests of their people from the center and all that. Their main interest is politics. If their main interest is covering themselves from corruption, it's something I cannot authoritatively say. But one thing I have come to understand over time is that there is lack of political will on the part of Nigerian leaders to address the issue of corruption. It's not about the smoke screen you see every day with prosecution of cases. And that is why most of these cases have lingered. Because there have been little or no seriousness. And, there is a body language you will get and from your superior, and you will take certain things extremely serious. So what I see in Nigeria here is just mere lip service. We have not yet gotten the leadership that we need to address or fight this issue of corruption.
So what would you pinpoint as, solely responsible for the many unresolved, high-profile corruption cases in our courts today?
Well, the last time I came here, I made some very, very important points, and I tried to identify some of these issues. Just for the risk of repeating myself, I had earlier said that there were a lot of factors. One of them is politics. When you are fighting corruption from the standpoint of politics, you will certainly not make any headway. And you will certainly be faced with a situation where those cases will be elongated as a matter of holding down a political opponent. You use corruption cases as, let's say, a long rope with which you tie your political opponent. You don't have any basis for some of this prosecution. Even if you do, you prefer to stretch the process so as to contain your own selfish interests as a politician. We have seen cases where people are being prosecuted because they are not protecting the interest of the government of the day, either at the state or the federal level, or the local government level. And at the end of the day, what you have is some sort of drag, because their interest is in putting down this person, making this person. A few weeks ago, former governor, the present governor of Bauchi State, Bala Mohammed, was complaining bitterly that because of his refusal to join the APC, his commissioners are being dragged by the EFCC and ICPC every day, on and on. His commissioner for finance He's always being called, come and answer to this and answer that. And he said that if not for the immunity, they would have also dragged him. Now, whether that is true or not is one thing, but the point is that he is pointing a finger, or he's pointing fingers at the leadership of at the presidency, or at the leadership of the country, saying that you are using these anti-corruption agencies as a fighting tool against me. And of course, Senator Bala Mohammed is not the first to say that. He is not the first. So we have had it over and over and over again, where these anti-corruption agencies are used as political baits against political opponents. And once they get you, sometimes they have to drag on these matters so that they can continue to have you on the leash. Another thing is, like I said, the role of legal practitioners.
Okay.
Do we really play the role we ought to? Do we really do the things we ought to do? As a prosecutor, before you say a matter should proceed to court for filing, have you appraised the evidence?
Okay.
Have you appraised the nature of the case to see if there are actually strong bases for this case? You know, the last time we spoke here, I gave you an example of the case against Justice Ademola.
Yeah.
And I remember I said that his case was thrown out on the ground of no case submission. The point was, what was the essence of all
The drama.
the drama around his arrest?
Pulling down doors.
Good, and the whole prosecution. As a prosecutor, did you sit down to check, to appraise these charges, or was it just something that just there to be done? There was a case that there was a scenario that was on social media of a prosecutor who came to court and told the judge that the IPO witness, the investigation police officer, was not in town and he was not available to give evidence. The defense counsel said it was a lie and told the judge to permit him to put a call through here in the presence of everybody. And he did. And when they called the officer said he was in his office. Here in Abuja, he was in his office. That may be as a result of the failure of the prosecutor to actually inform this witness that you need to be in court. And then he had to come to cover his shame to lie. So we have a lot of factors. I also mentioned that the last time, I just want to conclude with this one, that there is this habit by prosecutor agencies to, first of all, arrest before investigation.
Sometimes carry out sting operation.
I'm telling you,
without any
with no background work. They have not checked on the person. They don't have any background information. They have nothing to confront the person. Boom, they go to arrest. And when they arrest, they are under pressure by virtue of the law
to provide evidence.
No, not the other by virtue of law, to charge the person to court within 48 hours.
Okay.
Or grant bail.
Okay.
Sometimes they are reluctant to grant bail because they know that if they release this person may interfere with the investigation. Sometimes they're quick to go to court to charge the person. And when they charge the person, if it's a bailable offense, the court will release the person. The person will now go back home to start interfering with investigation. Good enough, the ACJA right now has permitted them to go to the court to say, please, can you give us an extension to hold this person in custody for 14 days?
Like what they are doing to the former Attorney General of the Federation now.
That is another case altogether. But you will also see that even that thing is being abused right now by prosecuting agencies.
Okay.
Instead of them to release the person, they will prefer to hold the person beyond 48 hours and run to court to get that order. At the end of the day, you will see that even after that first 14 days, they go for another 14 days, 28 days. They may go for that next 14 days. The judge will say, no, enough is enough. They may be doing that in the process. A habeas corpus proceedings will start. And they will be called upon to come and explain why they want to keep holding this man in custody. So at the end of the day, when you have done all these things, you don't have any concrete basis to prosecute. When you come to court as a prosecutor or as a prosecuting agency, they will end up dragging the whole matter and it will linger. So there are a lot of factors that are involved in this thing, but let's see if these three factors can be addressed. And in the long run, we will be making a lot of progress.
Okay, all right. We have been with the guest in the studio with me, Ugochukwu P. Isiguzo is a legal practitioner who has joined me today to do a review of some of the cases we have treated on this program, and of course to also try to look at the perception, the public perception about the judiciary in the country today. And we are going to take a quick break right now. When we get back on the second half of this program, we'll delve into that issue of public perception about the judiciary and the lingering cases, how we can, better our justice dispensation in Nigeria today. Please don't go away. We are just going to take a quick break. And when we come back, my guest in the studio will continue with me on the program. Stay with us.
I report. Have you ever witnessed a crime or suspicious activity around you? Don't stay silent. Take action. You can now report crimes easily by sending videos to us on I Report. Record a video and a brief narration of the incident with the location and send to 0701 372 8007 on WhatsApp only. Your action could help save a life or stop a crime in progress. Stay alert, stay safe, be the voice, take a stand. I Report, only on Third Eye Africa.
Welcome back from that break, and if you have just joined me, this is Code Files on Third Eye Africa TV. We are looking at the judiciary, the fight against corruption in Nigeria today, and the public perception about the judiciary is what we are going to be talking about in this second half of the program. I still have with me in the studio Ugochukwu P. Isiguzo. You are welcome to the second half of this program. And I want to thank you for finding time to join me on the show today. Like you heard me mention when I before I went on that break and when I returned, the judiciary. Yeah, they say the judiciary is the hope of the common man, and that used to be the saying. But I don't know about today. Who is the common man to you? Is it the politicians that are the common men or the common man in the streets? What do you make of that today? Do you still think Nigerians still believe judiciary to be the hope of the common man as we speak today?
The perception of the society of Nigerians about the judiciary as of today is not in a positive light. The perception is, if you go to the social media, you remember vividly, if you can remember during the election petition procedures or cases of Tinubu, Atiku, and Peter Obi,
Yes.
there was this big billboard that was raised somewhere around the express
Okay.
there, the Kubwa Express,
Okay.
saying that judiciary, our eyes are on you.
Yes.
The people, as of today, have some sort of negative perception about the judiciary.
Okay.
But you see, the truth of the matter is that part of the reasons why this negative perception exists, part of the reasons are lack of knowledge.
Okay.
A lot of Nigerians do not have knowledge of how the judiciary works.
Okay.
A lot of Nigerians do not have knowledge of how the law works. A lot of Nigerians are very, very emotional, and the judiciary do not work with emotions. You know, if I slap you here and somebody heard the sound of the slap outside, and the judge comes here, you tell the judge that I slapped you, the judge asks you for the evidence. You say you heard it outside, but you didn't see it. The judge may say, but that's not enough. Somebody outside will be shouting, but true, I heard him slap, that was a slap. At the end of the day, he will go outside and tell people that the judge does not know what he has done because there was a slap and the judge said there was no slap. The perception of the people, of Nigerians, one, the issue of knowledge. Once they address, you see, a lot of Nigerians, even those who say they're educated up to the doctorate degree level, when you see them speak or you hear them argue or you read them write, you ask yourself, what is the basis upon which these people are doing this? Some of them don't ask questions. I'm very sure that your follow-up on some of these cases for some time now has expanded your knowledge and on how most of these things work. Yeah. You could see that a case came up, somebody said the statement was not obtained voluntarily, and the judge has called for a trial within trial. That is the law. That is the law.
Yeah, but what many people are arguing is that, okay, now let me just give you an example. The NBA Anti-Corruption Committee warned that unresolved high-profile corruption cases is eroding public trust in the justice system. I think some of these things, technicalities are involved, like you rightly mentioned. But what's your take on this? Do you think delay tactics is also part of, I think delay tactics is also part of the whole process. Do you think lawyers or legal practitioners are deliberately exploring that delay tactics to frustrate the
Yes, there may be cases where people are busy delaying the process. Lawyers, legal practitioners, or even judges, or even clerks, or even the defendants themselves delay the process. It is not a one-sided thing. It is possible from all angles. Okay. And actually there are cases where where these things are being done. But the point is that the perception of the people about the judiciary should be based on facts and knowledge.
Okay.
However, there is no falsehood in saying that there is some sort of apprehension on the part of the people when it comes to the judiciary.
Okay.
We have had cases where people have expressed their serious discontent with certain things that have come out from judiciary. I remember Leonard Silk Olisa Abakoba speaking on a live television program too, and made a statement. He said, as at the time they started their own practice as legal practitioners, you could predict the judgment of the court based on established legal principles. Okay. But that is not so now. He was expressing his discontent. He said that is not so now. You could argue a particular legal position, and at the end of the day, the judge brazenly, discards it and goes for something else. There are judicial decisions where the higher courts have come heavy on lower courts to say, look at the position of the law. You intentionally refuse to apply it, and you are going this way, and you left the position of the law. So there are, bad eggs that have given the judiciary the bad name. But the truth of the whole matter is that it is like every other government institutions, okay, where there must be an intentional effort to clear the whole system, okay, and to make it work. Because retired Justice Amina Oge was speaking in a program, and she was talking about how she was in the I think when she was at the Court of Appeal or Supreme Court, a person has been in the department for more than 20 years.
Okay. And
you could imagine the kind of impact that person will have on the process. Those are the kind of persons that can be given money
to influence,
and a file will be missing.
Okay. You
will come to court every day, you can't find that file. They'll call the case, the file is not available for the judge to treat it. So these people also contribute. These people also contribute to give the judiciary the bad perception that it's having. But there is an aspect that has worried me for some time now.
Okay.
And that is the fact that the judiciary right now seem to be tilting more towards increasing its fees for the activities that go on within the judiciary. Okay. I was speaking to a colleague. I said, is the judiciary actually the hope of the common man? Can the common man actually walk up to the judiciary and spend the kind of money required of him to spend? The filing fees are growing high.
Okay.
They are growing high, both at the Court of Appeal and at the Supreme Court. You know, when you think of the cost of going through the whole process, when you have a decision from the High Court to appeal to the Court of Appeal, the cost is still there. How many people can afford it?
You have to bear another cost to file that case.
You have to pay to file that case. You have to compile the record. It's another cost on its own.
So the cost of justice.
The cost of justice, as of today, can the ordinary man actually afford it? Can the ordinary man actually afford it? Even when you, as a legal practitioner, of which this the justice sector is your farm, you decide to probably go pro bono for a particular case. When you look at the cost of prosecuting that case, the person who you want to even help pro bono cannot even afford it.
So what that implies is that justice is for sale, it's not for common
man.
No,
I don't agree that it's for sale. It's not for sale.
Okay.
But you may say that the cost is rising.
Yes.
And is getting out of the hands of the ordinary man.
You have to be able to afford it for you to get justice. First, you have to be able to afford it.
But I must also inform you that there are procedures involved where you cannot afford it. There are things the law allows.
Like legal aid council.
Legal aid council. There are also procedures within the civil procedure rules.
But I've not heard the legal aid council. A lot of people that have tried exploring the option of legal aid council have no good stories to tell as well.
I don't know about that. There is an office in the Ministry of Justice called the Public Defender's Office.
Okay.
They're also there to help people who have challenges with meeting the finance or the cost of some of these things. There are also procedures within the law that you could apply, for example, to the Chief Justice, say, look, I cannot afford
to get a representative.
I'm not necessarily just to get a representative. I cannot afford to go through the whole process.
Okay.
Can I please be allowed to do it without paying, or can I please be allowed to do it at low cost? Okay. But the point is that these things are there, but how easy are they
accessible
to be assessed? And how, like you spoke about the Legal Aid Council, and like I talk about the public, are they really equipped? You know, sometimes it's just like when you go to the police station, you walk into the police station to report a complaint. The policeman will ask you, will I use my fuel to go and arrest? Because there is no provision for it. You get me? When he wants to do investigation, sometimes he will tell you to come and, because he cannot use his own salary to do those things. So even most of these organizations and these processes that are put in place by law to enable people to pursue justice at low cost, the point is how much of support the government give to these institutions to enable them help the ordinary man to pursue justice.
Okay, now let me just take you to the next concern, which the NBA also raised in their New Year message. The NBA talked about worry over silence and delay over high-profile corruption cases, corruption allegations, this time around involving lawyers. What impact do you think this has on this public perception? I'll just quickly make a reference to one of the cases involving a high-profile lawyer, which involved Mike Ozdekome, SAN, in alleged property between him and late Jeremiah Oseni in UK. The trial was in the UK, but it got to a point, several factors played out involving forgery of documents, involving a third party that is said to have acquired the property, was said to have acquired the property from. Now, this raised questions about corruption within the bench itself. So, What impact do you think that is also having on the public perception about the justice system?
Of course, like I earlier said, there are a lot of, I've always said it, the justice system has a lot of hands in the pot.
Yeah, you talked about the people that have stayed in a position for over a period of time that could get a file missing. So now I'm
Good.
putting it to the other side now.
With legal practitioners,
Yes.
of course, legal practitioners also contribute. Some legal practitioners are actually the purveyors of this corruption. Some legal practitioners are actually involved in, and that is why you see in the Nigerian Bar Association, we always push for the discipline of most of these legal practitioners. A lot of legal practitioners are losing their licenses because of these acts, because of these activities. You know, a lot of legal practitioners are being disciplined because of the activities they are getting themselves involved, which are capable of tarnishing the image of the legal profession largely. Recently, a branch of the NBA appointed a person who has been convicted of corruption. A branch of the NBA appointed a person who has been convicted of corruption as a patron. And the NBA president said, no, you cannot do that. You are giving us a bad name. Somebody that has been convicted for corruption, for stealing public funds, you are making that person a patron for your branch. What is the meaning of that? What is the implication? And immediately the president called upon that branch chairman and his executive to withdraw that kind of appointment and retrace their steps, of which I believe they have done that. But the point is that the NBA is raising most of these concerns because they believe as an institution that we should not contribute to the decay. We should not contribute. We should not, by express or implied activities, contribute to these things. There are situations where lawyers have been involved even in money laundering. But most times, what the NBA will not do is to speculate. Once there are clear-cut evidence that these things have happened. I was speaking with a senior colleague a few months ago, and he is in the disciplinary committee with regards to this whole thing. And he was giving me a serious warning. He was saying, look, this when you want to do this with the client, be careful, take certain steps, be careful, don't just let your guards down, because sometimes you may be a tunnel through which corruption activities may be carried out. So yes, there are senior lawyers who are involved. There are junior lawyers who are involved. But the point is that we must all put our hands on the table to ensure that these issues of corruption are being addressed irrespective of who is involved.
Okay, so what do you think the judiciary can start doing now to start regaining that public trust? Because like I was having a chat with you before we came into the studio, if you have a fight with a friend now over a piece of meat in a restaurant, the next thing he will tell you is go to court. Going to court, telling you go to court means different thing to an average Nigerian now.
I have had that experience. A case that we handled, and in the association, our client was told to go to court. That go to court right now means it's an implied way of saying nothing will happen. And I totally appreciate and understand your concerns, Charles, about this whole thing. But the judiciary sincerely needs to look for a way to address the issue of delays, because that is the reason why people say go to courts. If I know, this case I was telling you of, before we could conclude, it was an election case in an association. Before we could conclude the case and the judge gave the judgment, the tenure had expired. So why wouldn't somebody tell someone else to go to court?
So that implies when they say justice delay is not justice denied, that is no longer practicable now.
Justice delayed could be justice denied. It could be. And there are obvious cases like that. So the judiciary must begin to think of how to reduce make things faster for themselves. I've spoken about this, and I'll keep speaking about it. There is a need to work out a system that will be very effective and fast. Because once we are able to do that, once the judiciary is able to do that, the judiciary will be able to regain confidence. I know that if I slap you now and you are going to court to complain of the thought of battery, the case will be concluded within, some reasonable period of time.
Yes.
So when I talk about judiciary addressing this thing, it also involves dealing with its internal institutional issues. The last time I came here, I gave an example of where you go to court. There was a time, it's no more like that anymore, but there was a time at the Court of Appeal here in Abuja. You will go to court, and a bailiff of court will stand up and say, "My lord, we did not serve hearing notice." And nothing will happen to that bailiff. You will go to court, and a process which you filed at the registry, at the Court of Appeal, you file nothing less than 15 copies of a process. Nothing less than 15 copies. At the end of the day, you may end up leaving 10 with the registry. But when you get to court, they call the matter. You will be shocked to find out that those copies, about 10 copies you left, not one is inside the file. Not one.
So,
and nothing happens to anybody whose responsibility it was to put those things in the file.
yes, but
That case has been delayed for that day.
yes, so what can this sector, this judiciary do about those things? Are there no checks, balance, and even penalty for offenses?
Of course, there should be. That is what I'm talking about. There should be. Somebody should be there to ask, why was this document not put into the file? Whose responsibility was it? Query that person. Recently, I just as we are speaking about this, okay, let me not go that far, but query the person. Ask the person, why did you not do it? Can you explain why these documents were not in the file after it was filed and released for you at the registry? Will you put the person on suspension? When you put the person on suspension, others whose responsibilities are similar will sit up.
So now we are talking about just high-profile, corruption, of course, criminal trials. I also want to extend my concerns about the congestions we have in our correctional facilities today. That is also part of the whole process and the whole part of the system. How do you think these people can also be factoring in this whole speedy dispensation, that justice dispensation that we're talking about here?
It's also the same thing we're talking about. There are a lot of factors when you come from that angle also. Sometimes the correctional service, Nigeria Correctional Service, play their own role in enabling this congestion, in the sense that they will have seen cases where inmates that were supposed to be brought to stand trial were not brought. And when you were asked, there was no fuel.
So I'll tell you, their vehicle broke down the road. And that case is delayed for that particular day.
Sometimes, but most of the reasons why you have this congestion is largely as a result of prosecuting agencies.
Okay.
You have started trial against somebody. When they don't have evidence, what will they do? Keep seeking adjournments. And the person is still in custody. People are waiting trial for 2, 4, 5, 6, 7, 8, 9, 10 years.
Yes, and sometimes they even spend more years
than the sentence.
The sentence. So how can you possibly compensate somebody for that kind of injustice?
That is what you're talking about.
So now we will now begin to coast home at this point in time. I want you to give me your parting shots. You need to give us some recommendation as to way forward in terms of
like I've been saying delivery. I've been saying here, every person who is having a role to play in the justice system must be held accountable. The person must also be called to sit up and do his job.
Okay, now held accountable by who? Who is supposed to be doing that?
For example, the judges report to their chief judges, their chief justices. They report to NJC. NJC should be able to look into some of these cases. We have situations where a judge can. There was a case there are cases where throughout the year, a judge will not sit to hear a particular case.
Absolutely.
Because each time the case comes up, the judge is not sitting.
With no reasons. I have been to court and a judge was not available.
Sometimes the reasons are very frivolous. Sometimes reasons are very, very frivolous. So, could there be an inspection group that goes around to say, did this court sit? Or could there be a sort of feedback mechanism?
Yeah, because that's why people are alleging selective trial, especially with not just peculiar to this government. But do you think we have a form of selective? Because there are some cases that you see some level of speed, some weekly hearing or day-to-day trial and all of that. I don't want to mention names now.
Of course, we have them, especially when it comes to political matters.
Yes.
The speed with which these political matters are dealt with. That is why I tell you that most of our problems are coming from our leaders. Recently, there was an attempt to amend the constitution to say that if a case comes before a court, it should have a limit within which a time frame within which it should be concluded. There was a serious opposition to that amendment, that proposed amendment. However, the politicians were very comfortable with putting that same time limit when it comes to election petitions.
And that was why I was raising the question of, do we need special courts to try corruption and criminal trials?
For me, like I've said, and I've kept saying, you asked me this question last time, and I said,
you said no.
There is no need.
Some other people have
we are not. If you establish a corruption court, these factors affecting the whole system will also affect that one. It's an attitudinal problem. It's an issue of leadership.
So you agree with me that there's selective trial in terms of, especially corruption trial?
I don't know about corruption trial, but generally I can say that there are cases that has been dealt with serious expedition of with serious attention and timelessly finished, especially when it comes to politics, up to the Supreme Court in less than a year. The Supreme Court even gives decisions. Why is it that there is so much leaning towards speed when it comes to political matter? The life of the ordinary Nigerian who is being held in custody or who is dragging, whether he was slapped or not, is it not important? It's very, very important. Sometimes you go to court and you see the way some of these cases are being dragged. But when it comes to a political matter, expeditiously it is dealt with. Let me tell you something. Sometimes it's not just the judges that are the challenge. The legal practitioners themselves, because they are heavily paid, they deal with these matters with expeditiousness and finish it up. The judge will give them 3 days straight and they will come with their witnesses. But when it comes to the other ones, so there are a lot of things that are involved. I have an appeal that I have been trying to deal with since 2019. Each time the matter comes up, the court will not sit. Since 2019.
And that's the essence of this program. That's a code.
Since 2019.
That's a code case.
Since 2019. Each time that application comes up, the court will not sit.
5 years down the line. 6 years now.
These are this 2020, we are going to 2027 election. Once it starts, you hear the appellate courts will say they are no more hearing ordinary cases. They only want to give attention to political cases. And I ask myself, is it that these ordinary cases are not important? Yes, political cases are very, very important because they deal with the issue of governance for the country. Perfectly agreed and right idea. But before this period, what is the attitude towards disposing the ones that are on ground? What is the attitude?
So, in your final words, what do you think is the way forward? Is it a hopeless
No,
situation?
it's not. No. There are, see, the leadership of judiciary, they are beginning to make a lot of effort. I told you of the way it was at the Court of Appeal in Abuja.
Yeah.
But it's no more that way.
Okay.
You get me? You can, when in fact, if you go to Court of Appeal Abuja now, you find a lot of progress. You find a lot of progress. The only truth and the only thing that is needed is that we need a feedback system.
Okay.
The judiciary should begin to think of a feedback system. People should be able to, even if it's baseless, people should be able to give back
The assessment.
the assessment of the whole system. If I am having a case before a judge, I should be able to assess the activities of that judge. It may not be, it may be emotional, it may be biased, it may be because the case is not going my way, no problem.
But they should take the feedback.
But they should take the feedback. Because if I am complaining of the same thing, 10 persons complain of the same thing, 20 persons complain of the same thing,
Then there's element of truth in it.
so there should be a feedback system. It will help the judiciary to address most of these internal issues it is having. And once these internal issues are addressed, I'm telling you that the perception of the society about the judiciary will be very, very positive.
I think that is a very perfect place to. I think I want to borrow the words from the court now. We should adjourn this now. I think it's a very good place to adjourn it for today. And I have been on the program for the last 50 or 50 something minutes thereabout with Ugochukwu P. Isiguzo, who is always willing and ready to add his voice to this conversation when it comes to justice dispensation in Nigeria. And if you have joined us from the beginning of the program, you will agree with me that he has really thrown a lot of lights into the dark areas that we as ordinary people have, been having question marks in our head as to whether the judiciary is still the last hope of the common man, whether the saying "go to court" still makes a lot of sense as we speak today. And I want to sincerely thank you, Isiguzo, for coming around.
Thank you very
to
much.
add your voice to this conversation.
Thank you very
And
much.
of course, I have always said that we'll continue to bring you in from time to time to assess the process.
Thank you.
And we have also talked about the lingering cases in our courts and the way forward of these, delays and numerous unresolved, and of course the congestion in our correctional facilities, and of course the justice sector, the corruption in the justice sector as well. And that is where we're going to draw the curtain on the program today, Cold Files. Will come your way again, same time on same station. Please keep watching Third Eye Africa TV, your home of crime investigation. Community safety is our priority here. And please remember, security is everybody's business. It's everyone's business. It's my business, and it's your business. Look around your environment. Don't forget to take advantage of our iReport platform. If you see anything, you can take a photo or you can do a video. You're in a safe environment to do that. Ensure you do that and get back to us, and be rest assured that we'll follow up and keep you up to speed with safety tips and, of course, crime prevention around our environment, and make Nigeria safe for all of us. And that is where we'll be calling it a day today on the program. From me, Charles Agedo here, I would say see you next time on the program.